Right, any rebuttal argument on behalf of the state?
Yes, Your Honor. Ms. Hollins went back and forth between whether or not Blaise Taylor even thought he was the father of this child. She said that Jade Jackson said she wasn't sure. You heard the testimony. I submit to you that Nigea said she was sure, it's just he wasn't involved. And she was saying that at the hospital because he was telling the people at the hospital that he loved Jade more than her. And she was, that was not true. That's what she testified to about whether or not he was the father. She told all of the officers, he's just the father. He's not involved. But Ms. Hollins argued to you that he wasn't the father, but then she also wants you to consider a text message where Jade is telling her mom that he signed up for a diaper service. You can't have it both ways. Also, Blaise Taylor told people he was the father of her baby. He told Keontae, Nigea, the people at Vanderbilt. He told the police officers. Now, when he calls 911, he's with a friend. But when the police come, that is his girlfriend. He is absolutely committed. And the text messages with Xavier Winford absolutely were not submitted for any purpose of saying somehow Mr. Taylor was a bad person because he was seeing more than one woman. It was for that very purpose. He had someone that he loved, that he was telling, I love you. But also the rest of that thread is that something's happening, but everything's going to work out for them. But it's very much against what he told the police, that Jade Benning was his girlfriend. His interactions with her, it wasn't I love yous. She also wasn't going to admit he's the father of the child, but yet wants to say that they picked out the baby's name together. Well, Nigea Jackson testified about that, and she was very specific that that was a name that Jade suggested, and he agreed. He didn't disagree with it. But you also heard testimony that Jade's unborn baby girl's name is Ivy. She, just to clarify, I don't know where the Lauren Weber-Mario connection came from. I submit to you that the evidence that you heard was that Mario texted Jade. Jade texted Danny. Danny wasn't in town. No one met up. Lauren Weber was not involved in that. Lauren Weber went to the apartment, and her testimony was that it seemed too clean. And she told the officers that. That was the first thing she said to them. She went in, and it was so weird to her that she took 2 pictures, and she walked the apartment. I submit whatever happened within the police department for officers to not go there that night and seize that scene, absolutely. That is a mistake. That should have happened, and it did not happen. But it doesn't change anything. Thank God for Jade's family and friends that they were not happy because nothing was happening, and it needed to happen. And they took care of it. There was nothing that was disturbed. Now, Mr. Taylor in the cleanup, he did not put the camera back. And they put the camera back where it would be, where it would face the door, not knowing if he could come back in because the police aren't there. Ms. Hollins also argued that somehow if he wanted to kill the baby, that he wouldn't be wanting updates from Jade's mom. Jade's mom's updating him because nobody knows yet about the cocaine. That first drug screen in the hospital, it was negative. Nobody knows what's happened. She referenced the cause of death with Dr. Carney. Not the cause of death, the manner of death with Dr. Carney. And she put the report up, and it very clearly states that there's a suspicion for homicide because it's possible that she ingested the cocaine without her knowledge. Someone gave it to her. But Dr. Carney's determination has nothing to do with yours. Your determination is reviewing all of the evidence to determine what proved beyond a reasonable doubt. If she determined it was a homicide, you could not consider her determination for your decision. That is for the death certificate. Ms. Holland's arguments to you about Blaise Taylor. We wish we had the surveillance video. Yes, it would be much better if we had the surveillance video, but not to exculpate him. It would show him going in and out. How long was he out there before he went back inside on 911? How many times did he go out there? It would show Jade Benning pulseless the way he saw her being carried out by the EMTs. There is nothing about that undoes the proof in this case. She argued that a chef would know that there was something in a drink. Jade Benning absolutely said, I knew there was something in my drink because I tasted it. Those are the facts. Ms. Holland's entire argument is asking you to ignore the testimony that again was unimpeached by Nigella Jackson, that Jade Benning said all of these things. She said them to him. It's only the two of them in the apartment. He says it's only the two of them. He says Jade was talking to me. Her arguments to you are asking you to not only ignore everything that Jade Benning said, but it's to ignore that if for some reason it was true and Jade Benning ingested the cocaine herself to kill herself and her baby, and then called her best friend and said these things to Blaise Taylor, and Blaise Taylor never tells anyone what she said. He doesn't, when he sees Nigella, say, oh my God, what happened? She said these things. I didn't do anything. We have to figure out what's going on. That is absolutely not true. He didn't tell anyone what Jade said. And when Detective Smith asked him if Nigella would have any reason to make up these accusations, he didn't even say she was making it up. He said, I think she's just in shock, and I was the last one with Jade. There is no explanation because Jade Benning said these things. It is the proof and evidence in this case. Jade Benning named her murderer and the murderer of her baby, and she told you why. The state does not have to prove the why, but Jade Benning
told you why. And I submit to you that the evidence in this case is proof beyond a reasonable doubt that Blaise Taylor is guilty of all 4 counts of the indictment. Thank you.
Members of the jury, count 1 and 2 of the indictment in this case charge the defendant Blaise Taylor with the offense of first-degree premeditated murder. This offense embraces the lesser included offenses of second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide. Counts 3 and 4 of the indictment in this case charge the defendant Blaise Taylor with the offense of first-degree murder during the commission of a felony. This offense embraces the lesser included offenses of second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide. The indictment of this case is a formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create any inference of guilt. To this indictment, the defendant has entered a plea of not guilty. The evidence and arguments in this case have been completed, and it's my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, I've ruled upon the admissibility of evidence. You must not concern yourself with these rulings, neither by such rulings, these instructions, nor any other remarks which I've made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been or as to the reason for the objection, and you must assume that the answer would be of no value to you in your deliberations. You must not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken out by the court. Such matters to be treated as though you had never known it. You must never speculate to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. Sometimes in the trial of a criminal case, when a defendant is charged with a crime or crimes, this crime or crimes include lesser included offenses. The law permits the jury to find the accused guilty of the lesser included offense, which is included in the crime charged in the indictment, whenever a course of conduct is consistent with the facts found by the jury from the evidence in the case and when the law is given in the instructions of the court. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in light of your own observations and experience in life. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The court will now instruct you as to the law applicable to all counts of the indictment. First, it will set forth the laws applicable to the crimes charged in the indictment. Finally, it will describe for you the deliberation process. Counts 1 and 2, first-degree premeditated murder. Any person who commits the first-degree premeditated murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Any alleged victim includes a human embryo or fetus at any stage of gestation in utero. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and that the defendant acted knowingly. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The definitions of intentionally and knowingly which apply to this offense have been previously explained to you in these instructions on page 6, and you should refer to those definitions as they apply to this instruction. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Counts 3 and 4, first-degree murder during the commission of a felony. Any person who commits first-degree murder during the commission of a felony is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate an alleged first-degree premeditated murder. That is, that the killing was closely connected to the alleged first-degree premeditated murder and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the alleged first-degree premeditated murder. For the defendant to have been found guilty of first-degree premeditated murder, the state would have had to prove beyond a reasonable doubt the essential elements of first-degree premeditated murder, which have been previously set out on page 5 of these instructions, and you should refer to those instructions as they apply to this offense. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged first-degree murder. The killing may precede, coincide with, or follow the first-degree premeditated murder and still be considered as occurring in the perpetration of the first-degree murder, so long as there is a connection in time, place, and continuity of action. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Any alleged victim includes a human embryo or fetus at any stage of gestation in utero. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, as to count 1. As to count 3, Jade Benning, and as to count 4, the unborn female child of Jade Benning, and 2, that the defendant acted knowingly. Knowingly means that a person acts knowingly with respect to the conduct or circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established that it if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The definitions of intentionally and knowingly which apply to this offense have been previously explained to you in these instructions on page 6, and you should refer to those definitions as they apply to this instruction. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, and 2, that the defendant acted recklessly. The definition of recklessly has been previously defined to you in these instructions, and you should refer to that definition as it applies to this instruction. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, and 2, that the defendant acted with criminal negligence. The definition of criminal negligence has been previously defined to you in these instructions, and you should refer to that definition as it applies to this instruction. When you begin your deliberations on the indictment, you must first deliberate on the indicted or charged offense. If you find the defendant guilty of the indicted offense, you may stop your deliberations as to the remaining charges within that count of the indictment. If you find the defendant not guilty of the indicted offense, or you have a reasonable doubt, then you must find the defendant not guilty of the indicted offense and next consider the lesser included offenses as set out in your verdict form. You must first deliberate on the greater offense and reach a verdict as to the greater offense before you move on to the next lesser included offense. If you reach a verdict as to the guilt of the defendant as to a greater offense, you may stop your deliberations as to that specific count. If you find from the proof beyond a reasonable doubt that the defendant is guilty of murder in the first degree as to counts 1, 2, 3, or 4, then it shall be your duty after a separate sentencing hearing to determine whether the defendant will be sentenced to life imprisonment without the possibility of parole or life in prison, but you will not consider punishment for this offense at this time. I noticed that some of the jurors appear to be making notes during the trial of this case. Please bear in mind that these are your notes and for your use alone. The taking of notes is simply an aid to memory, and the jury must understand that they are to recall the testimony and to use the notes only as an aid to memory. And any juror who takes notes will use those notes only for that juror's assistance in that regard and not as an authoritative thing to show others. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. The court charges you that if you are satisfied from the whole proof in the case beyond a reasonable doubt that the defendant, Blaise Taylor, committed the crime charged against him, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the crime charged, then it would be your duty to convict him. On the other hand, if you are not satisfied with the identity from the proof, or you have a reasonable doubt as to whether he has been identified from the whole body of proof in this case, then you should return a verdict of not guilty. During the trial, you heard expert testimony of Dr. Michael Olashoga and Dr. Kelly Larkin, who is described to us as an expert in the field of emergency room medicine, Detective Tom Miller, who is described to us as an expert of the field of digital forensics, Dr. Aaron Carney, who is described to us as an expert in the field of forensic pathology, Dr. Carrie Midthen, who is described to us as an expert in the field of forensic toxicology, Eric Devlin, who is described to us as an expert in the field of digital forensics, Nicole Dowell, who is described to us as an expert in the field of forensic science drug identification, Dr. Alex Kroltulski, who is described to us as an expert in the field of forensic pathology, Dr. Melissa Giguere, who was described to us as an expert in the field of forensic toxicology, and Dr. Janice Lindsay, who was described to us as an expert in the field of forensic toxicology. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness. It is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Direct evidence is defined as evidence which proves the existence of the fact in issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact in issue, but from which that fact may be logically inferred. It is evidence that proves one or more facts from which you find or infer the existence of some other fact or facts. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. An inference is a reasoned, logical decision to find that a disputed fact exists on the basis of another fact. You should consider all the evidence that is presented in this trial direct and circumstantial. The law makes no distinction between the weight that you should give either direct or circumstantial evidence. It is for you to decide how much weight to give any evidence. You're the exclusive judges of the credibility of the witnesses and the weight to be given their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can without hastily or rashly concluding that any witness has sworn falsely. For the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any, are shown, and all the evidence in the case tending to corroborate or to contradict him or her. A witness may be impeached by proving that he or she has made material statements out of court which are at variance with his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such statements. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved in the trial. If from the evidence presented you find that a witness has been convicted of a prior crime, you can consider such only for the purpose of its effect, if any, on his credibility as a witness. The defendant has not taken the stand to testify as a witness, but you should place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Tape recordings were allowed in evidence, and you were provided with a document purporting to be a transcript of the audio tape. This document was provided to you to assist in your listening to the audio. If from your listening to the tape you find discrepancies or inaccuracies between the transcript and the tape itself, you should rely upon your understanding of the tape and disregard those portions of the transcript you find to be inaccurate. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Davidson County, and that it was committed before the finding and return of the indictment in this case. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. In that event, your foreperson will report that you found the defendant guilty and name the offense according to your previous instructions. On the other hand, if you find that the state has not proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt, then you must find the defendant not guilty. In that event, your foreperson will report that you find the defendant not guilty. You will be provided with a form for all possible verdicts in this case. For each count, the jury will check the appropriate verdict on the form, and your foreperson will sign the verdict form. The verdict form which you'll receive reads as follows. Verdict form. We, the jury, find the defendant Blaise Taylor, count 1, first-degree premeditated murder, and count 1 and 2, the verdict forms is the same. Choose 1. Guilty of first-degree premeditated murder, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of reckless homicide, or guilty of criminally negligent homicide, or not guilty. Count 3 and 4, the verdict forms are the same and read as follows. Count 3 and 4, first-degree felony murder during the commission of a felony. Choose 1. Guilty of first-degree felony murder during the commission of a felony, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of reckless homicide, or guilty of criminally negligent homicide, or not guilty. There's a signature line for the foreperson and a line for the date. When you retire to the jury room, you will first select one of your members as a foreperson who will preside over your deliberations. When you have reached a verdict, you will return to this courtroom and your foreperson will announce it. You must not imagine that the court has any opinion in regard to the facts. It is your duty to find them, and have attempted to read this charge so as to define to you the law without indicating any opinion about the facts whatsoever. Members of the jury, the indictment in this case is herewith handed to you together with the charge and the exhibits in this case. You may now retire and consider your verdict. And let me swear in the court officer. Do you solemnly swear or affirm that you will keep this jury committed to your charge, keep them separate and apart from all citizens, allow no one to communicate with them or communicate with them yourselves on the subject of the trial?
I do.
All right, let the lawyer step up just a moment. Regular jurors, if our 4 alternates, I'll speak to you in just a moment, can stand right there against the wall there. The other 12 of you, if you'll step down the hall, we'll get these items to you. All right, the alternates, obviously the court never knows whether we'll need someone to substitute into the deliberation process or not. Would have expected a week ago, Monday last week, that we probably would, but we didn't. So I appreciate your service. You'll be discharged from this case. We'll shred your notes for you, and you can step out with the court officer. All right, we'll be in recess.
Court's in recess.